And so we come to our closing arguments. A time when we must stand up for our ethics, our regard for international law, and the highest values of justice that the ICJ stands for. As I speak before you today, Your Honours, I beseech you to uphold these values and ask yourself a simple question. Is this the precedent that we want to set forth? Do we want to convey to future generations of international lawyers that misusing domestic disputes, breaching sovereignty and twisting international law and twisting international law to strong-arm a smaller, helpless nation is correct? That is the question that we as members of the ICJ must answer today. And that is why we, the advocacy of Cyprus, must reiterate the facts that we have so unambiguously and clearly set forth before the committee today. Let us begin. As stipulated between the two parties, the Turkish continental shelf intersects with the Cypriot EEZ. The Turkish government has repeatedly attempted to muzzle international attempts to solve this crisis plaguing the Eastern Mediterranean region, citing on numerous occasions that they are not signatories to the UNCLOS and are therefore not bound by any of the obligations that they are supposed to fulfill. Yet, as Article 36 of the Vienna Convention of the Law of Treaties states, all third parties that accept their rights as part of treaties also have to fulfill their obligations. In addition to this, it has been rather unfortunate, to say the least, that Cypriot actions which were taken in good faith have not been reflected by the respondent side. As a proud signatory to the UNCLOS, Cyprus has clearly held the articles of this document in the highest regard, especially Article 83, which is written with regard to the delimitation of the continental shelf. Yet Turkey has shown us that it is capable of nothing but bad faith and backstabbing. While Cyprus acts in good faith, Turkey does not. Let us now come to the issue of equity. As per the North Sea continental shelf cases, cited by Turkey in their own memorandum, the principle of equity is one of prime importance. Yet, praetor equity legem, Your Honours, does not mean that the ICJ can overrule pre-existing borders simply with regard to the principle of equity. Turkey happens to find itself in the unfortunate position of being the only country to recognize the Turkish Republic of Northern Cyprus, a de facto puppet state that was propped up by Turkey after the 1974 invasion of Northern Cyprus, which was, by the way, ladies and gentlemen, a blatant violation of the 1960 Treaty of Guarantee, which categorically stated in Article 3 that guarantor powers, Turkey, Greece, and the United Kingdom, were to respect the sovereignty of Cyprus, which was left under the occupation of the United Kingdom at the time of the signing of the treaty. These are the facts, Your Honours. While we as advocates cannot decide the verdict of this case, and will be more than willing to accept the verdict of this course on this case, we have a few words to say before we close. This case is not just one of legality. It is also one of ethics. It is about the rights of thousands of Cypriot people whose dreams of peace, stability, justice, and economic development were dashed just 14 years after independence from the British because of betrayal by one of their guarantor powers. As I close my arguments, I would like to remind you of the Cypriot farmer, the lawyer, the businessman, the taxi driver, every one member of our island's population who have been denied their economic rights just because Turkey finds it necessary to twist international law and make absurd claims on our EEZ. Think about this, Your Honours, as you ponder over this case. Thank you.
It's been proven abundantly clear that the government of Cyprus does not speak for, represent, or recognize the basic citizenship of those living in the Turkish northern half of the island. And so, esteemed justices of the International Court of Justice, of course, I question why it wouldn't be considered anything other than a necessary and legal right for the government of Turkey to act upon their obligations as a guarantor power. Obligations that Greece, who's never been much of a friend of Turkey, of course, would say they would do given the exact same circumstances before us today. Much has been made these past couple of days about Turkey being some sort of a violent provocateur, yet by all accounts, it has been Cyprus as that key violator. Who violated the agreed upon state of affairs by attempting to overthrow the government when it wasn't skewed heavily in their favor? The Greek Cypriots did, of course. Who was it that restricted the full participation of the oppressed minority group on the island? The Greek Cypriots. Who is it that subverted and toppled a universally supported and acclaimed plan for peaceful reunification on the island? The answer to all of these is none other than the Republic of Cyprus. And so, when my opposing counsels present this baseless case for Turkey as a violent aggressor, I ask you, honorable judges, I ask you to please beware the wolf in sheep's clothing. We've argued a variety of issues, and you rightly may be wondering, why are you discussing humanitarian issues in a maritime law case? To that, again, I propose that this doesn't exist in a vacuum. To truly understand the scope of this case and to reach a solution that is both equitable and acceptable for all, both Greek and Turkish Cypriots, one must truly understand the background and factors that yet again contribute to this present state of affairs. Something that even Greece and Turkey were able to do in 1960. Something that was violated repeatedly and egregiously by the Republic of Cyprus. Something that the united international community attempted to reach again in 2004, just to be torpedoed by the greedy Greek Cypriot majority, as my partner would call it. Beyond all the jargon and rhetoric throughout this case, at the heart of this is the fact that Turkey has been the party moving towards a lasting resolution in good faith, despite what Bulgaria may have said there, without any backing for it. This issue cannot be decided simply within the guise of the room, but rather from a broader, more holistic approach which ensures the inherent rights of all people on the island.
Now, some of you may be thinking, what do these broad truths have to do with this specific case at hand? You may say, great, but I'm here to weigh evidence on a specific, very narrow maritime delimitation case. You might think, this isn't at all tied to it. Yeah, let's say that despite the 1974 Greek Cypriot coup aimed at union with Greece, despite the exclusion of Turkish Cypriots from all facets of the supposedly all-inclusive Republic of Cyprus, despite the systematic marginalization of a minority group that denies them a political, economic, and international voice, including in this case, you remain unconvinced that this case must reflect larger considerations of fundamental human equality. Let's say that despite all the evidence to the contrary, you really believe that when the international community recognizes the Republic of Cyprus, that it means it represents all Cypriots equally. Let's say that regardless of the complex historical web this case resides in, you take the strictest and narrowest possible view of this case. I propose to you that even if you reject all of our larger arguments, which I believe would be a mistake, Turkey still has the better case. So far in this case, my opponents have claimed that, as Adele mentioned, Cyprus is, for some reason, the victim. They have depicted themselves as perfect followers of international law, whose actions stand in stark contrast to the rogue ways of the Turkish. Yet what evidence backs up this narrative? Our opponents give unilateral Greek Cypriot laws establishing an exclusive economic zone precedence over Turkless declarations of a continental shelf. They assert that agreements by the Greek Cypriots with third parties, such as Egypt and Israel, dictate where Turkey may claim its continental shelf. Why? Because they refuse to consider the Greek Cypriot actions are taken with selfish motives and attempt to restrict Turkish freedoms. Let me clearly state Turkey's case for this maritime area. Turkey has consistently laid claim to its continental shelf, as demonstrated by its objections to the Greek Cypriots agreement with Egypt and its repeated protest to the UN over the Greek Cypriots completely disregarding Turkey's continental shelf when delimiting its EEZ. Turkey's claimed continental shelf adheres to the universally recognized principle of equity, which, as explained in past ICJ decisions, such as the Black Sea case, means all relevant factors must be considered. Yet the Greek Cypriots insist that only their agreements and laws are legitimate, and that any Turkish claim is necessarily illegal. This idea is not only unfair and provocatory, but also a complete legal fallacy. Let me state it clearly. The Republic of Cyprus has not presented any legitimate evidence clearly establishing that its claimed EEZ should be accepted over the claimed continental shelf of Turkey.
Well, as Henry VIII said to all of his 6 wives, I won't keep you very long. This rhetoric of internal issue that the Republic of Turkey has been going on and on about since the beginning of this case is absolutely brilliant. To confuse you, judges, to confuse you, to confound you, to move you away from what this case is actually about, because they know that the facts are not in their favor. They know that their agreement with their continental shelf agreement is not legal, it is not valid. They know that it is Cyprus which deserves the disputed zones. And so they try to confuse you. Not one piece of evidence in their whole packet which can prove why they deserve the disputed areas, apart from one treaty, one bilateral agreement with the Turkish Republic of Northern Cyprus, which is a unilateral claim. This may seem like a bilateral agreement, but it is actually a unilateral claim. Is it a coincidence that the Turkish Republic of Northern Cyprus is established immediately after the invasion of Cyprus by Turkey in 1974? Is it a coincidence that the TRNC is called the Turkish Republic of Northern Cyprus? Is it a coincidence that there is heavy Turkish military presence in the TRNC? The government of the TRNC is an illegitimate one and influenced heavily by Turkey. And this agreement cannot be treated as valid. All the evidence is solely what the Republic of Turkey's beliefs are, but it actually doesn't get out there and prove anything. All the letters dated which try to prove that Cyprus has done any drilling whatsoever is a claim by Turkey in a letter. There is no actual evidence that this actually happened. No map, no coordinates, no Cypriot statement that this is happening, just a Turkish statement which could be completely fabricated.